Thank you, Ludmila. Thank you, dear colleagues, honorable guests. It is very important that the problems of Belarus are not just internal problems, and that our foreign colleagues see those issues, help us to keep Belarus in the focus of international community, keep on the agenda the topic of violation of human rights. It's very important to us. So I would like to talk about the many aspects of the problem of torture and share my thoughts on what opportunities do we have using the international law to resolve the situation of impunity that Pavel mentioned. A lot of time has passed since the first report of the use of torture, mass torture, which was used systematically. And up until present day, I would like to stress not a single criminal case has been investigated, not a single person has lost their job. So first, I would like to bring your attention to the fact that the prohibition of torture is one of the absolute human rights, and it is a principle that is not just mentioned on the regional, but also on the international level, on the international humanitarian and criminal law. The Convention Against Torture has currently been certified by 169 states, which indicates an international consensus on the elimination of torture and ill treatment. So it's important to understand, if we talk about the prohibition of torture and ill treatment, then we have two important issues. First, responsibility of the states and individual responsibility of specific persons who committed those crimes. So I would like to start from the prohibition of torture, which has been established on the international level, and it's a violation of human rights. Belarus, as a participant to the International Pact on Civil and Human Rights, has undertaken responsibility under Article 7, which states that no one should be subjected to torture or cruel, inhuman, or degrading treatment of punishment. So we see that Belarus violates this article. First of all, it directly uses torture. And second is the lack of effective investigation. So this is what we can talk about today. What problems do we face if we talk about the violations of the pact? And what opportunities does this tool provide to us? So as participants, we have a right to address the Committee on Human Rights, to address this committee on the basis of violation of Article number 7. Well, the problem is the duration of consideration of such cases. Currently, it's about 8 years to reach a decision. And the second issue, of course, is the fact that our state does not want to comply with the views of the HRC. So our state um, has representatives in the UN in Geneva and says that all the decisions of the Human Rights Committee are only recommendations, so our state doesn't have to implement them. Of course, we can also submit under Article 31 claims, and this procedure can be used when a certain state has provided its statement, and Belarus has done so. It has acknowledged the competence of a Human Rights Committee to review multinational claims. So we don't have a single claim in this area yet. However, in other committees, we have cases already, so this opportunity still exists, and any state can address HRC on the basis that Belarus does not comply with its obligations under the pact. When we talk about HRC, I want to say that Belarus has not accepted the competence of the committee under Article 21 to review individual or multi-state claims. The only opportunity for the mechanism to function is Article number 20, which means that committee, if it receives proved information that of cases of use of torture, it provides the state with opportunity to collaborate on the investigation of such claims. So, as it turned out, this procedure is also very lengthy, and of course, HRC has limited capabilities, and the main issue is the fact that the state has to comply. So, even if we see that inside the state there is absolutely no desire to go into the detail trying to establish if violations actually took place, so there is no point going using these instruments internationally. I also want to touch upon the question which our forum began with. So, what is very important to remember that um, the prohibition of torture is an obligation erga omnes, and we're talking about obligation towards the whole international community. So it's been internationally accepted that the prohibition of torture is a jus Hobbes norm. So basically, the international UN court in the case of Barcelona um, has noted uh, that obligations are governance. Obligations are that each state takes upon itself in the face of all states as a whole, and the fulfillment of which it is legally interested, as well as in the position of UNILC. So it is important because our today's situation, which continues in Belarus, is not an ended story. We have new cases of torture in September and October, and it is possible that they'll continue in the future. So it's not just internal issues of the state. Those systematic mass prohibitions, violations of human rights, including torture, are now on a different level. So protection of those rights becomes an obligation in the face of international community. I would also like to touch upon torture as a national crime. So, as Michael said, although there's not a separate article in Belarus, we still have a number of articles criminalizing torture and talking about this specific situation that happened in August in particular. We can talk about Article 128 of the Criminal Code, which states crimes against uh, the security of mankind and provides a deportation, illegal detention, enslavement, mass systematic executions without trial, kidnapping followed by the disappearance, torture, or acts of population are punished with imprisonment for a term of 725 years, or life imprisonment or death penalty. So I would also like to note a very important moment that not so long ago, our criminal code had an appendix to this particular article, which prescribed what torture actually means. And they took a citation from the Convention Against Torture. So basically, our criminal code describes torture exactly like the Convention Against Torture. So, what does it say? We have a specific framework which allows us to use in within framework of various national legal systems, this unified description. So basically, it doesn't allow a dependent state to interpret torture how they like. We all have to follow this one universal regulation. So the question of jurisdiction, which has been established by the Convention Against Torture, has been discussed previously. So I would like to stress that Belarus, of course, is a party to that convention, and this convention obliges states to implement jurisdiction on the territorial principle, principle of nationality, principle of victim and their nationality. But I would like to add that we have the first signs of implementation of this article. We know that in Poland there's been a criminal case instigated on the fact of torture of two journalists, and we will follow closely what happens next. And last is the fact that the state can take measures which are necessary to establish jurisdiction if the persecuted person is present on any territory. So that's talking about international law. And the last topic I would like to touch upon is connected to a convention against torture. I would like to mention Article 7 of the Statute of the International Criminal Court. So we talk about crimes against humanity, and torture falls under that, and other inhuman acts of similar nature also included. So the statute also views torture in a slightly different description compared to the UN Convention. So torture means the willful infliction of severe pain or suffering, whether physical or mental, on a person who is in the custody or control of the accused. But torture does not include pain or suffering that results only from legal sanctions, is inseparable from those sanctions, or is caused by them accidentally. So all the terminology is a little bit different from the terminology of a convention against torture. Here we have the key elements that are exactly the same. So we talk about the infliction of severe physical or psychological pain and suffering. It's not a question about the element of state as a subject of the crime, but there is an element of control. And this element is viewed very broadly. We're not just talking about being under custody, which, talking about the situation in Belarus, is applicable to absolutely all situations of use of torture in uh, basically any rooms of the police departments where people basically did not go through any legal procedure. So if we talk about the terminology of international criminal court, we can say that the events that took place can qualify under this description. Talking about the practice of the tribunals, the, especially tribunal on former Yugoslavia, the practice of tribunal has developed a description which is based on the UN Convention Against Torture and does not contain any additional or very different elements of crime that basically help us to qualify what happens in Belarus at the moment as an international crime. Talking about the main issues related to international crimes, of course, the fact that Belarus is not a member of an international criminal court, so its jurisdiction uh, is not applicable to us, is non-reachable to us, and with the current authorities, we cannot implement any of its decisions. Talking about tribunals that are established by the UN Security Council, then we have to raise the importance of this question internationally, and of course the necessity of support of 5 current members of the UN Council, and we all know the country that is one of those members, and of course this will never happen. So of course, as a lawyer, I am worried that the longer the conflict will last, the longer this legal default situation will go on. There is a possibility that when the authorities will change, there won't be enough specialists in the legal system, in the prosecution system, who would be able to carry out investigations of what happened and legal persecution of those who committed those crimes, because the longer this torture and violence cycle goes on, the longer persecutors remain inactive. Of course, they will be punished for their acts, not just a regular police officers will be held responsible, but also persecutors who must initiate criminal cases. They will be punished too for their inaction. So if we talk about the change of regime in Belarus, there'll be a question: who will investigate those cases? Who will judge those culprits? So I would like to end here.